constitutional law question from February of 2007 is another straightforward and simple constitutional law essay question. This hypothetical focuses our attention on commercial speech and association standing. Neither one of these issues are terribly difficult, but with a fact pattern this short, you need to make sure to do a comprehensive job of spotting the issues, and you need to do a sharp job of organization. And of course, you need to do another comprehensive job of applying the law to the specific facts in the pattern. Take a look with me at the call of the question. What arguments could AOR reasonably make to show that it has standing and that its First Amendment free speech claim has merit? And would it be likely to succeed? Discuss. Well, as we consider standing issues in the abstract, we think about suffering a redressable harm, etc. As it turns out, this is yet another con law question that is asking us about association standing, perhaps the simplest issue in all of constitutional law. And it breaks down into a simple, bite-sized, three-part test. Apply the facts to the test and move on. Then the First Amendment issue likely will be more complicated, and we'll see in our work together far more complicated First Amendment issues than the ones that are presented in this question. Go to the top of the question. Let's review it together. In the first paragraph, we learn about the ordinance at issue. It is an anti-smoking ordinance designed to deter children from smoking by banning advertising on billboards, store windows, and any site within 1,000 feet of a school, and then the quoted language, any other locations where minors under the age of 18 traditionally gather. Okay, well, stop right there. Doesn't that look a little vague to you? Doesn't that look a little unspecific? Well, it is. Move on. In paragraph 2, we learn explicitly about the purpose, to discourage kids from smoking. And we see the likely result. A lot of advertising is going to get pulled in the vicinity of schools, daycare centers, etc. Now, notice, it's possible to get confused if you don't read carefully. The first paragraph has the quoted language from the statute. The second paragraph, talking about the effects of the statute, gives names several different places where kids congregate. Well, other than schools, none of those other locations are mentioned in the statute. And that would be one way to fix the statute, to mention specifically those other areas where kids might congregate. In paragraph 3, we learn about AOR, the Association of Realtors. Stop right there. We can outline right there. We can answer the first part of this call of the question very simply. It is a straight association standing issue, and we'll be able to very comprehensively go into the law. The reason we're going to have time to go into the law is because there's nothing else to do. This fact pattern and the issues presented are so thin that we've got to make the most of everything they give us. So we find out about this association. They are arguing a couple of things. They're arguing that it's going to cost them a lot of money in lost revenue. And they also argue that there are lots of better ways to prevent kids from smoking, and they say restrict their access to tobacco rather than reduce their exposure to advertising. Then, in the fourth paragraph, we find out that AOR is considering filing a complaint for injunctive relief against the city in federal court over the First Amendment. Okay, fair enough. Then we get the call of the question once again. Well, we really have to do careful work organizing our answer to this question with a fact pattern this short and the issues so narrowly and specifically defined. We've got to do our very best at spotting the issues and applying the facts. So please turn the page and let's take a look at the outline of issues that I've offered for your consideration. And you'll see once again, I'm not really doing anything that should surprise any of you greatly. Look at association standing. Once again, I'm just using the elements for association standing as the framework for our analysis. The lawsuit is relevant to the association's purpose. The individual members of the association will have standing, but individual members need not participate, so the bottom line is this association certainly has standing to litigate these First Amendment issues on behalf of its members. Then we turn to the free speech arguments. Once again, I focus briefly on standing, ripeness, and mootness, and state action. We establish standing in our answer to the first part of the question. Then we go to commercial speech. Notice how I lead, even in the outline, with the standard, a substantial relationship with an important governmental interest. That's the standard that we apply to commercial speech. If you don't know it, this is a good reason to learn it. All of the different constitutional standards of review should be on your short list of things to memorize, because being able to come up with them in response to a specific question like this one is really essential to success. Next, I focus on the other elements, that the ordinance advances a government interest and that it is narrowly tailored. Then I focus on vagueness. But you'll notice there are problems with this statute, plenty of them, and I strike it down as being void for vagueness. But this is not a statute that would be very difficult to fix. We could turn this into a constitutionally acceptable statute with just changing a few words. So, now, let's have a look briefly at the model answer that I've offered. You'll see that I really do a lot of work to examine carefully not just the facts that are in the pattern, and not only the elements of law that are at issue, but I go one step deeper in a couple of places to really show how much thought I've put into the issues presented. With regard to association standing, here I do find a way to go beneath the superficial surface level of the analysis. I lead with the facts about who the association is, and I also define association standing. And you'll notice this definition is a little more elaborate than many of the definitions that I use throughout the written materials of the Master Essay Method program. And the reason why there's more law in this answer than in many other answers is I have time for it here. This is not a racehorse question. This is a question where they pretty much spoon-feed us the issues. But we've got to know the elements. Beyond that, there's just not a whole lot to do. So I put plenty of law into this answer, maybe a little bit more than usual. Then, focusing on the elements, clearly this lawsuit is relevant to the association's purpose. This is a trade group of retailers. Any statute that would reduce their ad revenue would impact negatively their revenues. So it's certainly relevant to their purpose. The individual members would have standing, but only up to a point. Take a look at a couple of short paragraphs that I've presented under this section. Here is an example where I go a little bit further to really think about these issues. Certainly plenty of members of the Retailers Association wouldn't have standing to contest this law because they don't have tobacco ads. How many tobacco ads do you think are present in, for example, toy stores? 0 already. So not every member of the association would have standing to contest this law, but a lot of them would, and that's good enough to meet that element of the association standing test. Then, focusing on the fact that individual members need not participate, this is much more standard stuff. I'm not going beyond the facts presented. I conclude at the very top of page 2 that association standing has been shown. Next we turn to the free speech arguments, and here I do very little in terms of introduction, just a couple of short sentences. Then I focus on ripeness, mootness, and state action, and this is a question that has more to do with the First Amendment than with standing, than with ripeness and mootness. But I don't leave it out altogether. And you'll notice, here again, I find room for a number of specific details from the pattern. One of the comments that I often make as I critique the practice work of my students is, I advise my students to be better journalists, to find a home for the explicit facts, the specific details from the question, rather than merely alluding to them in more general terms. And here, in my ripeness, mootness, and state action section, I'm following my own advice. The case is ripe. It is not moot, and the city's actions constitute state action. So, we move to commercial speech. And here, you'll notice that I present all of the facts, and I go into the law in a fair amount of detail. Realize that with regard to commercial speech, it is perfectly okay to ban false or misleading speech. And as I go into the analysis in the advertising itself, particularly with regard to connecting the statute to having a substantial relationship with an important government interest, one point that I make, which again requires a little bit of extra thinking, is advertising works. Advertising is effective. And so restricting the kids' access to tobacco advertising almost certainly would advance that government interest in keeping young people away from tobacco. So this is an example where the question is short enough and simple enough that we've really got the time to work carefully to analyze the situation. So it seems to me that given how even the plaintiff in this action, the association, agrees with the basic goal, that it's good to keep kids away from smoking, ultimately they've got problems in contesting a ban on advertising. So I conclude that restricting advertising for smoking is substantially related to an important government interest, and also this ordinance directly advances that government interest. You'll see, here again, I am very specific in discussing how advertising is effective, and thus restricting kids' access to advertising is likely to equal fewer kids taking up the habit. Then I focus on whether or not the statute is narrowly tailored. Ultimately, I've got a problem with the quoted language at the end. That's the problem with this statute, and that's why we're going to find for the plaintiffs in the end with regard to the vagueness issue, and perhaps also with regard to the issue as to whether or not the statute is narrowly tailored. So I conclude that the statute is void for vagueness. But you'll also see that I clearly indicate that the statute doesn't have to be changed very much to make it entirely satisfactory and completely up to constitutional standards.